the August 8th, 2019 meeting of the Medical Board of California, Panel B. I'm going to call the meeting to order and ask for roll call, please.
Ms. Friedman?
Here.
Dr. Gonadev?
Here.
Dr. Kraus?
Present.
Dr. Mahmoud?
Yes.
Ms. Pines?
Here.
Ms. Lawson?
Here.
We have a quorum.
Thank you. Agenda item 2 is election of a vice chair. Do we have any nominations for vice chair of this esteemed panel? Any additional nominations? Seeing none, would you like to accept the nomination, Susan?
Of course.
Right, if we could have a roll call vote on the election of Susan Friedman to vice chair. Do we need a roll call vote?
Ms. Friedman?
Yes.
Dr. Gonadev?
Yes.
Dr. Kraus?
Yes.
Dr. Mahmoud?
Yes.
Ms. Pines?
Yes.
Ms. Lawson?
Yes. Congratulations. Moving on to item, yeah. Moving on. Yeah, just wait till you get to sign all the orders and then people find out who you are. Yes. Great. Thank you. Moving on to agenda item 3, oral argument on judicial remand, Patel. I'm going to turn over the proceedings to Administrative Law Judge Crowell from the Office of Administrative Hearings. Thank you.
All right, thank you. Good morning. Can you hear me? Yes? Okay. Good morning.
Good morning. Mary Kane Simon, Supervising Deputy Attorney General, appearing for complainant, Your Honor. Good morning.
Good morning.
Good morning, Your Honor. Albert Garcia, appearing for the respondent, Dr. Patel.
All right. Good morning, everyone. We are on the record in the matter of the accusation against Moneil Patel, MD, following a judicial remand. This matter has been assigned Medical Board Case Number 800-2016-027195 and Office of Administrative Hearings Case Number 2019-07-0602. Today's date is August 8th, 2019. My name is Melissa Crowell. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over these proceedings today. At this time, let's put our appearances officially on the record, starting with the Attorney General's office.
Supervising Deputy Attorney General Mary Kane Simon, appearing for complainant, Your Honor.
Good morning.
Good morning, Your Honor. Albert Garcia, appearing for the respondent, Dr. Patel.
Good morning. In making your presentations today, you should keep in mind that the board members have read your written argument and that the argument can be based only on the existing record. Mr. Garcia, you will be allowed 15 minutes for your opening argument, and then, counsel, you will have 15 minutes for complainant's closing argument. Each party will have 5 minutes for their final argument. After the hearing, the board will meet in closed session for deliberations. The board's decision will not be announced today. All right, Mr. Garcia, you may proceed. And do you want me to give you a 5-minute warning?
Yes, Your Honor, if I get that far.
Okay.
Thank you very much. I appreciate it. Good morning. This is an out-of-state disciplinary case that was based entirely on action taken by the Arizona Medical Board. And in that action, Dr. Patel was reprimanded and placed on probation for a period of 6 months. The case is back before the board under mandate of the Superior Court of Sacramento County. The board has asked the parties to address the following issues relating to the penalty. Number one, of course, the protection of the public, the circumstances surrounding the misconduct, the likelihood of the conduct recurring, and any mitigating factors that should be considered. As to the circumstances surrounding the conduct, the record shows that the conduct underlying the Arizona disciplinary action occurred in a very unique setting, wherein Dr. Patel was working as an independent practitioner with a firm known as Life X Med, or MD, which offered elective hormone replacement therapy primarily for men seeking to improve their strength or stamina. I mention that unique circumstance because it will also factor into the issue of the likelihood of this misconduct recurring, which I will address in a moment. The Arizona board found that Dr. Patel failed to maintain adequate medical records and that deviated from the standard of care in the treatment of two patients that he saw back in 2012 and 2014 while he was working for this Life Ex Med. The deviations from the standard of practice had to do with the prescription of medications without an adequate physical examination and without medical indication. Those were the deviations, apart from the record-keeping issues. Based on those findings, the Arizona board reprimanded Dr. Patel and placed him on probation for 6 months. Now, as to the likelihood of the conduct recurring, since leaving Life Ex Med in 2014, Dr. Patel has been engaged in a completely different kind of practice. He's in a general practice now focusing on pain medication. He no longer engages in hormone replacement therapy, which got him in trouble in the first place. And there have been no other patient care issues concerning Dr. Patel since that time. So it's been more than 5 years, suggesting that this was an aberrant situation that occurred when he was working for this firm back in Arizona. The administrative law judge who heard the case noted that Dr. Patel had successfully complied with all the terms and conditions of the probation imposed by Arizona, and this is where we get into the likelihood of this conduct recurring, that the factual circumstances underlying the discipline, and I'm quoting now, occurred in 2012 through 2014, and that respondent has changed his practice in many ways since that time. Based on that finding, the ALJ concluded that all things considered, again I'm quoting, a public reprimand and a requirement that Dr. Patel complete a prescribing course will be sufficient to protect the public interest. As to mitigating factors, Dr. Patel flew out here from Arizona to attend this hearing, and he testified that he understood the board's concern with the conduct that led to the Arizona disciplinary action. He testified that he accepted responsibility for that conduct. He acknowledged that his documentation was deficient, including, in particular, the failure to document physical examinations in an adequate manner. And he testified to his appreciation that deficient documentation can affect patient care because subsequent providers will have an incomplete or confusing record of the care that he rendered. And the panel, of course, should consider as a mitigating circumstance that the two patient cases here date back to 2012 and 2014. And again, no other issues have arisen in that 5-year span. Dr. Patel testified that he gained valuable insights from the experience of having been disciplined by Arizona. In particular, he testified concerning the record-keeping course that he was ordered to complete and did complete, and described the knowledge that he acquired in that course and how he had implemented that into his own practice, testifying, for example, that he had already implemented electronic record-keeping into his practice at the time. Again, Dr. Patel complied with all the terms and conditions of probation imposed by the Arizona board, and that probationary term actually terminated in April of 2017 before this case was even heard here in California. In terms of character witnesses, there was testimony by Sandeep Lal, MD, a hospitalist with Kaiser Permanente Hospital, and he testified to Dr. Patel's, quote, good values, morals, and integrity, end quote. In addition, Dr. Patel presented a letter of support from his current employer at General Medical and Physical Medicine Therapy Practice in Arizona. I want to make a comment about the written argument submitted by a complainant. There were repeated references to patient harm in Arizona. And there was a finding of patient harm. But the patient harm that Arizona found was not physical harm. It was, as they put it, subjecting the patients to unnecessary therapy. Now, I'm not at all defending that. I mean, obviously, if a patient is subjected to unnecessary therapy, that's misconduct, no question about it. But the way that the argument is presented by complainant about patient harm repeatedly in the written argument tends to suggest that there was some sort of physical harm to the patient. Now, I understand physical harm is not necessary in order for the board to impose discipline. I understand that. The only thing I want to get at is that there is a reaction to a term like that. When you use a phrase, patient harm, over and over again, you tend to think of the patient actually being physically harmed or harmed in a medical way. So I would invite the panel to look at that decision very carefully and what the board actually found in Arizona, which again was unnecessary therapy. Now, the protection of the public, once again, after hearing all the evidence, the administrative law judge concluded that all things considered, a public reprimand and a requirement that respondent complete a prescribing practices course would be sufficient to protect the public interest. The board did not agree and imposed a harsher penalty, but I want to remind the panel that unlike the board and the panel here, the administrative law judge actually heard the evidence firsthand. The administrative law judge was in that courtroom assessing credibility, looking at the witnesses as they testified, evaluating and assessing their demeanor while they testified, listening to all the evidence firsthand. And the administrative law judge, again, based on all the evidence heard and considered, including the Arizona order and all the factual findings of Arizona, concluded that a reprimand was sufficient to protect the public interest. So Dr. Patel is requesting that this panel reconsider its prior disciplinary order and follow along the lines of what the Arizona board did, or in fact, just adopt the proposed decision that was issued by the administrative law judge. And on that question, obviously this panel is not bound by the Arizona board's decision to impose a lesser penalty. This board has the unquestioned authority to impose a more severe penalty than that imposed by Arizona. There's no question about it. I'm not making that argument. But I think, in all fairness, the board should look to and consider what Arizona did in this case. After all, Arizona is where the conduct occurred. Arizona is where the doctor was practicing and, in fact, continues to practice. Arizona, unlike this board, which really based its decision solely on the record of the Arizona case, the Arizona board had the opportunity to delve into the facts, to make factual determinations based on live presentation of evidence. So the way I look at it is this: if the jurisdiction where the conduct occurred deemed a reprimand appropriate to protect the public interest, if Arizona, which had the opportunity to hear and consider the evidence firsthand, deemed the reprimand appropriate for protection of the public, then where is the imperative for this board to impose a harsher penalty? I frankly don't see it. But I certainly respect the board's decision and the panel's decision on the issue, which is within the discretion of the panel, of course. Now, as to the remand, as I mentioned before, and as you know, this case is here on remand from the Superior Court of California. And the decision there and the judgment there is clear and unambiguous. The board has been commanded to issue a decision after remand in accordance with the court's decision and judgment that part of the probation condition number 1.
Mr. Garcia, I just want to tell you I have 5 minutes left.
Thank you, Your Honor. Mm-hmm. That part of condition number 1, that has to do with the assessment program. That part of it, which requires Dr. Patel to undergo a comprehensive physical and mental examination, may not be imposed by the board. And it may not be imposed by the board because, as the Superior Court found and determined, there was nothing in the record, no evidence, no charges, no evidence, no factual findings that would support that very intrusive requirement of requiring the doctor to undergo a physical and mental examination. So based on all my comments, I respectfully request that the board reduce the penalty, in this case to a letter of reprimand, as proposed by the administrative law judge, and that, in any event, it comply with the Superior Court's judgment and delete that part of probation condition number 1, requiring Dr. Patel to undergo a comprehensive assessment of his physical and mental health. Thank you, Your Honor.
Thank you. Ms. Kane-Simon?
Thank you, Your Honor, and thank you, honorable board members, for this opportunity. First, I'd like to talk about what the Superior Court's remand does not do. It does not require this board to reconsider the entirety of the penalty. Council has asked the board to reduce the penalty. This board has already considered that request. There was a petition for reconsideration, which is part of the record of the mandamus proceeding in Superior Court. This panel declined to reduce the penalty, and the panel's order fixing the degree of penalty has been upheld by the Superior Court. Superior Court's only issue with the panel's decision after non-adoption was with requirement for the comprehensive physical and mental examination that's a component of the clinical skills assessment. The clinical skills assessment requirement and all of the other requirements of the probation that this panel imposed on Dr. Patel were left intact by the court's order. Just to address the points that the board has asked us to address in regard to protection of the public. This board has already made a determination that public protection requires the 3-year probation period and the conditions that the board has already imposed. Dr. Patel cannot argue that the court disturbed that finding. The court did not disturb that finding. So this panel's already found that public safety requires the period of probation. Dr. Patel is required to undergo the clinical skills assessment. There's nothing before this board to undermine the board's previous decision that this is in the best interest of the public in California. The only requirement that Dr. Patel does not have to undertake in accord with the court's order is, as a component of the clinical skills assessment, he doesn't have to undergo what he believes to be an intrusive, comprehensive physical and mental examination. It's going to be up to Dr. Patel to work out with whatever clinical skills assessment program, how he can meet the program's requirements to engage in and complete that program in satisfaction of the board's order. And there's no evidence here today to say that he will not be able to do so. Council's not proposing that he would not be able to do so. They're accepting that this is the court's order. The circumstances surrounding the misconduct, and this is where this panel previously found that there was reason to impose a period of probation, the clinical assessment program, education course, as well as a prescribing course, in order to protect the public. Dr. Patel came before this board and he minimized his misconduct. This board has found that he minimized his misconduct unrealistically. He talked about having taken a course in physician burnout and stress that somehow he presented as an explanation for his misconduct in prescribing cosmetic hormone replacement therapy for men. The harm to patients in taking unnecessary medicines is something that this panel well knows can't be gauged in a moment. It is reckless behavior, and it can't be explained by physician burnout. So this panel caught that, and I think rightly recognized that public protection required putting a check on Dr. Patel's progress in his career and assessing what was going on with his medical judgment so that there would not be a repeat of that kind of behavior. Physician burnout doesn't explain that kind of reckless prescribing. The likelihood of the misconduct recurring, this board has already determined that there is a reason to make sure that the misconduct does not recur. The board found that Dr. Patel said the biggest error that he made was documentation. The board found that that was an undue minimization of his own misconduct. The board's determination has been left undisturbed by the Superior Court. There's no reason for the board to change its previous decision in that regard. Now, in regard to mitigating factors, I would note that counsel has gone outside the record and made a claim, which is not supported by any evidence before this board, that Dr. Patel has had a perfect history in the last 5 years. I don't know that. Counsel hasn't had an opportunity to present additional evidence. Dr. Patel's behavior in the practice of medicine is something that, if he is practicing in California, his probation monitor is going to be in a position to check on his progress and completion of the requirements of probation that California has imposed on him. It's speculation and is outside our record today, and counsel's statements to the contrary should be stricken to discuss what Dr. Patel has been up to in the last 5 years. That information isn't here today, and it shouldn't be taken as a given that his current prescribing practices would meet the approval of this board or would somehow obviate the need for the disciplinary order that this board has imposed and already has declined to reconsider, and that the Superior Court has upheld. In conclusion, I would say that this board's order has stood several tests, and there is nothing in the record today to do anything other than to go forward with the order that the board has already imposed, and it will be up to Dr. Patel, working with his probation monitors with the medical board, to undergo the clinical skills assessment that the board has ordered and find a way to meet the medical board's requirements.
All right, thank you. Mr. Garcia, you have 5 minutes.
Thank you, Your Honor. I want to address just a couple of points that were raised. As far as going outside the record, Dr. Patel is practicing in Arizona, so all the conditions of probation, under the standard terms and conditions of probation under the Manual of Disciplinary Guidelines, all those conditions are held in abeyance while he's in Arizona, with 2 exceptions. One, he must file quarterly reports. And 2, he must obey all laws, rules, and regulations. Those conditions of probation are not held in abeyance, even though he's in Arizona and not practicing in California. I mention that because if there were any issues arising with Dr. Patel in terms of his patient care or any other issue, they would have been reported under the quarterly report. His probation monitor would have known about it, and I've been doing this for 22 years. We would have heard about it by now. So I don't think that that's a valid argument. The other point I want to bring up is that what is the scope of this oral hearing today? I'm looking at the order here. The order that was issued for this oral argument, and it asked the parties to address the penalty, and in particular, protection of the public, circumstances surrounding the misconduct, likelihood of conduct recurring, and mitigating factors. Now, if we were only here to decide one issue, not really decided because it's been decided for you, the Superior Court said you have no alternative. You have to delete that requirement where Dr. Patel has to undergo a comprehensive physical and mental examination. That's not an issue. You have been commanded to do that. So if the scope of this hearing were that narrow, we wouldn't even be here. The scope of this hearing is defined by that order that I just read from. We're looking at protection of the public, mitigating circumstances surrounding the Arizona action, and the likelihood of recurrence. Those are issues that inform what a penalty should be. So I think that this panel is, by its own order, this panel is authorized to reconsider the penalty, and I urge you to do so. Thank you very much.
Thank you. Ms. Kane-Simon, 5 minutes.
Thank you, Your Honor. This board has already put a lot of work into considering the level of penalty in this case. There was already been discussion and debate. An administrative law judge made one recommendation. This panel came to the conclusion, which now the court has upheld, after counsel made pretty much the same arguments that he made here today, and after Dr. Patel presented himself to the board, and the panel found that public protection requires the elements of the disciplinary order that the board has already imposed. Dr. Patel raised with the Superior Court a number of objections, one of them being his right to privacy, to be free from what he would regard as an unduly intrusive, comprehensive physical and mental examination, which this board only ordered in the context of the clinical assessment program. As the board well knows, an assessment is it's a component of a clinical skills assessment program. Now, however he can gain admission to a clinical skills assessment program, whether he preserves his privacy by, for example, having his examination or assessment conducted by his own personal physician, and then presenting the report to PACE or whatever program the board has found acceptable that the doctor has proposed. That's going to be up to him and up to the program to work out how he can gain admission to the program and still be free from what he regards as the risk of an unduly intrusive physical and mental examination. Or he could potentially waive his right to privacy and undergo the examination, I think, as many doctors would reasonably do in those circumstances. What the court found fault with here is that the language of the order is that it's a comprehensive physical and mental examination, and the court found that that was overbroad in the face of the doctor's privacy interest, and that there was nothing in the record to support the idea that the medical board had spotted a need for a comprehensive physical and mental examination. Now, the order itself doesn't explain in detail what's going to go into that examination. The program, the clinical skills assessment program, I think, has some degree of flexibility there. But in the face of Dr. Patel's privacy objection, this particular order, based on this language, was found overbroad. And so Dr. Patel is not going to be required to undergo that examination. But however he can work it out to gain admission to the program, this board is still justified and has been upheld by the Superior Court in the requirement that he undergo the clinical skills assessment. So there is nothing that the court has done to say that Dr. Patel does not have to undergo the clinical skills assessment. It's simply going to be up to Dr. Patel to figure out how to work it out with the program to get the assessment done and to satisfy this board's legitimate order, which the court has upheld, that he undergo that assessment. All of the other requirements of probation, again, have been upheld by the board, upheld by the court, and also upheld by this panel of this board. The board has already reconsidered the penalty. The penalty was not done frivolously or without thought. This panel has already put in the work, and the situation is unchanged from what was before the panel when it formulated the prior disciplinary order. And I would submit that the panel should sustain its previous penalty, including the clinical skills assessment, and leave it to Dr. Patel to work out how to fulfill his obligations under the disciplinary order.
Thank you. All right, President Lawson, any questions?
No questions from me. Any questions from anyone else?
Any questions? All right, thank you very much. We are off the record.
Thank you.
Clear the room. The August 8th, 2019 meeting of Panel B of the Medical Board of California. We are back in open session as of 9:54 a.m. Agenda item number 4, oral argument on non-adopted proposed decision for Richard Neill Sauer, MD, and I'm going to turn this over to the administrative law judge, Melissa Crowell.
All right. We are on the record in the matter of the accusation against Richard Neill Sauer, MD, following a non-adoption of the proposed decision. This matter has been assigned Medical Board Case Number 800, 2017 040456, and Office of Administrative Hearings Case Number 2019 070601. Today's date is August 8th, 2019. My name is Melissa Crowell. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to sit with the board today and preside over this proceeding. May I have appearances for the record, starting with the Attorney General's office?
Megan O'Carroll of the California Attorney General's Office on behalf of complainant.
Good morning.
Good morning.
Good morning. What am I supposed to press here?
Green.
Good morning. Albert Garcia on behalf of the respondent, Dr. Richard Sauer.
Good morning, Mr. Garcia. In making your presentation, you should keep in mind that the board members have read your written argument and that the argument may be based only on the existing record. Mr. Garcia, you will be allowed 15 minutes for your opening argument. Ms. O'Carroll, you will then have 15 minutes for your argument. Each party will then have 5 additional minutes for closing argument. After the hearing, the board will meet in closed session for deliberations, and a decision will be issued thereafter. All right, Mr. Garcia, you may proceed.
Thank you very much. Members of the panel, I'm not going to rehash the facts of the case. The facts were discussed at length in the written argument, and I'm sure that you have read it. And the reason I'm doing this is the deadline for the designation of an expert witness was missed in this case, so Dr. Sauer proceeded to hearing without the benefit of an expert witness. Instead, I'm going to focus my remarks on one condition of probation, probation condition number 17 of the proposed disciplinary order, which deals with the clinical competence assessment program, and in particular, the condition precedent part of that condition, which prohibits or in effect suspends Dr. Sauer from practicing medicine until successful completion of the program. So I want to focus my remarks on that. But before I delve into that focused issue, I would like to respectfully remind the panel that Dr. Sauer has been on probation since May of 2018 on another case. And the conditions of that probation, which remain in effect, include a practice monitor, a no solo practice restriction, and the completion of courses in medical record keeping and ethics. I mention these to remind the panel and to assure the panel that there are conditions of probation already in place that are, I think, amply sufficient to protect the public interest. And the panel should also know that Dr. Sauer is and has been compliant with the terms of his probation. I wish to stress this one point, though. It is worth noting that although there is a prior case, and I'm using the word prior in quotation marks, the effective date of that prior decision was May 2018, 2 months after the filing of the initial accusation in this case in March of 2018. So it was a prior discipline, but only by designated prior. This is not a case involving violation of probation, in other words. So in a way, it's kind of misleading to refer to the prior discipline when considering what is an appropriate penalty in this case. Again, we're not dealing with conduct that constitutes a violation of probation, which of course would be an aggravating factor in determining an appropriate penalty, although the administrative law judge seemed to take that very view when she referred to the prior discipline in setting forth her reasoning for proposing the clinical competence assessment program, and in particular, proposing its completion as a condition precedent. I mentioned in the written argument, and I will touch upon it here just briefly, that in setting forth her reasoning for proposing the completion of the assessment program as a condition precedent, the ALJ employed language that is used in defining incompetence and not negligence, and certainly not simple negligence, which were the only findings made in this case. The ALJ stated on more than one occasion, it's in the record, it's in the decision, that the conduct in this case called into question, quote, respondents' general fitness to practice, end quote. As you know, Business and Professions Court, Section 2234, sets forth several genres of unprofessional conduct relating to patient care, two of which deal with the degrees of negligence. We have simple departures from the standard of care, repeated negligent acts, under subdivision C, and then we have extreme departures from the standard called gross negligence. And then there is a distinct ground known as incompetence. Incompetence is defined as an absence of qualification, ability, or fitness, the language used by the ALJ, or fitness to practice. Incompetence, which was not charged against Dr. Sauer, is distinguishable from negligence in whatever degree, in that one may be competent or capable of performing a given duty, but negligent in whatever degree in performing that duty. In other words, negligence in whatever degree is not the same as incompetence, as that term is defined by the statutory and case law of this state. And so to muddle the two distinct concepts, in my mind, is legal error. And in this case, I think it tainted the premise for the ALJ's proposed order in terms of making the competence assessment program a condition precedent. I want to stress this very clearly. Respondent does not in any way diminish the significance of any departure from the standard of care, whether it's deemed simple or extreme. But I think in all fairness, simple departures hardly implicate Dr. Sauer's general fitness to practice, particularly where one of the simple departures dealt with the legibility of medical records and another with his bedside manner. And again, there should be no misunderstanding. Respondent does not downplay the significance or importance of legible records. In fact, he acknowledged their importance during the hearing in his testimony. Or he certainly doesn't diminish the importance of effective communication with patients. But to suggest that these two shortcomings in this one patient case, call Dr. Sauer's fitness to practice into question, I believe, based on my experience, is stretching the findings well beyond their elasticity in this case. They just don't warrant that kind of assessment. So just what were the factual premises of the ALJ's proposed disciplinary order in this case? Well, the ALJ found simple departures from the standard of practice, even without the benefit or input of a defense expert. Now, I've been practicing representing medical board physicians before the medical board for over 22 years, and I can't think of a case where the completion of the clinical competence assessment program has been imposed as a condition precedent based on findings of simple negligence. I just can't recall. Maybe there are some out there, but I've never seen it. That is a penalty that is customarily imposed, reserved and imposed, when there have been findings of gross negligence or incompetence. But again, not in my experience have I ever seen it imposed when the findings relate simply to simple departures. So the question arises, why was that condition proposed here in this case? The only answer I could come up with is I go back to the misleading notion that the prior case should be viewed as an aggravating factor in fashioning the penalty. It should not. It should not for the reasons I've already indicated. That prior decision actually was rendered 2 months after the initial filing of this case. But apparently, from my reading of the decision, that's exactly what the ALJ did, ostensibly did at any rate, by referring to it. And I also reiterate my concern that the ALJ's repeated questioning of Dr. Sauer's fitness to practice based on findings of simple negligence tainted the proposed disciplinary order certainly with respect to making the clinical assessment program a condition precedent. Your Honor, I'm going to address this to you for a moment. I did raise this in a written argument. I don't believe it's within the scope of this hearing, so I'm not going to argue it, but I do want to preserve this issue for the record with your permission. That has to do with the reporter's transcript in this case. It is in the written argument.
Any objection?
No.
Okay, go ahead, sir.
Thank you very much, Your Honor. And again, I'm not going to argue the point. I just merely want to preserve the issue. Dr. Sauer made repeated requests for a copy of the reporter's transcript of his administrative hearing, and he did so under Government Code Section 11517, subdivision C2, capital E, small I, which expressly applies when an agency rejects or non-adopts a proposed decision. That provision reads, "A copy of the record shall be made available to the parties. The agency may require payment of fees covering direct costs of making the copy." Under Government Code Section 11523, the record is defined as including a transcript of all proceedings. I'm not going to say anything beyond that other than to say that the refusal of the board to provide that the reporter's transcript clearly impaired our ability to present an argument today. I'll conclude with these remarks. There are conditions of probation already in place that are amply sufficient to protect the public. The condition calling for the clinical competence assessment program, I believe, is unnecessary based on the findings in this case, simple negligence. Requiring the completion of that program as a condition precedent, thus suspending Dr. Sauer from practicing medicine for a period of time, is, I believe, entirely unwarranted, again, based on the findings in this case, which all relate to simple departures from the standard of practice. I'll conclude with this remark. As in the prior case earlier this morning involving Moneil Patel, which you will recall, that case was remanded from the Superior Court of California to the board on the question of the requirement requiring Dr. Patel to undergo a comprehensive physical and mental examination, because there was nothing in the record, no findings and no evidence in the record to support that particular condition. I'm going to make the same request of this panel. If this panel imposes the clinical assessment program in Dr. Sauer's case, I'm going to request that the requirement that Dr. Sauer undergo a comprehensive physical and mental examination be deleted, because again, there's nothing in this record, no evidence, no factual findings that would support that particular condition. Thank you very much, Your Honor.
All right, thank you. So, Carol?
The board has asked the parties to address the question of penalty in this matter, and specifically what level of penalty is appropriate to achieve patient safety. While I will address that question, I do have to first correct a couple of points that respondents' brief and argument now have misstated. They can't be allowed to stand. The first is respondent's mischaracterization of the facts of the record, and especially the expert opinion in his brief that was submitted here. And the second is this question of the transcript. As to the mischaracterization of the record, a respondent devoted a large portion of his brief to an attempt to basically relitigate the ALJ's findings of what the standard of care was and whether or not respondent violated them, and the fact that she found that he did based on the evidence. If you'll look, I think page 10 to 34 of respondent's brief, which is more than half the brief, is devoted to this subject. But in making this argument, he is distorting the facts of the record. I know that's not the primary issue the board has asked, but I'll just give one example because I think it is reflective of the rest of the case and is important for the board not to be misled. If you look on page 19 of respondent's non-adoption brief, he claims that the ALJ was wrong to find that respondent took an inadequate social history of the patient, and he disputes the expert's opinion that this was therefore a simple departure from the standard of care. So respondent in his brief states that the expert just assumed that respondent failed to inquire into the patient's history of street drugs and alcohol abuse. And that very likely respondent did in fact do so, and the patient just didn't want to admit negative facts about her history. Now, this is a complete mischaracterization of the evidence because respondent, in fact, admitted that he did not ask the patient about street drugs or alcohol use in his interview with the board, which was evidence before the ALJ and evidence that the expert considered informing his opinion that respondent departed from the standard of care. That is in the record at Exhibit 12 at pages 29 to 30. In his interview with the board, with the medical board consultant, asked respondent, did you ask the patient about her history of drug and alcohol abuse? Or said, first of all, did you ask about alcohol? And respondent's answer was very curt, don't recall. Later on in that interview, the medical board consultant asked, did you ask about street drugs? Again, respondent's very curt answer, don't recall. So the medical board consultant dug in a little deeper and he said, well, hey, I'm looking at the record here. Did you document that? Respondent's answer to that question was, street drugs are not documented here because it had no relevance here. So what he's basically saying is that he didn't need to ask about it. He knows best. And so for them to argue and ask the board to think that the ALJ misstated the evidence or that the expert was wrong based on these facts, that is a complete mischaracterization. The evidence that the ALJ relied on in her well-reasoned, thoroughly assessment of the facts of this case determined that respondent committed 5 separate departures from the standard of care. This was based on the medical records and respondent's own statements and evidence, as well as the expert opinion of the only expert who testified at the administrative hearing. So his whole argument, he's basically asking the board to disregard the evidence, to substitute his own opinion about his care for the patient, to find that he did not, in fact, commit several serious departures from the standard of care with this patient. And that must be rejected. The other question, the other mischaracterization that respondent made is that he was somehow claiming he was denied due process by not being provided with a copy of the record, of the reporter's transcript. That is a mischaracterization because what he's really claiming is that he was not provided with a free copy. And the reason he was not is because the government law prohibits that. The Attorney General's office was similarly not provided with a free copy of the reporter's transcript. The order that went out setting this matter for hearing today told both parties, if you want to obtain a reporter's transcript, here's the contact information. For that, you can purchase it from the court reporter. And the Attorney General's office did, and that's why you see it here before you. Respondent had an opportunity to do so if he chose and chose not to. And just for reference, it's the board's May 14, 2019 order setting this matter for hearing that gave both parties the opportunity to obtain that record if it was so deemed appropriate. So finally, turning to the issue of penalty, there are 3 main issues that I'd like to address here. First, the fact that respondent claims that the ALJ was somehow confused or muddled in her opinion, that she treated this as a probation violation. That is absolutely not what the ALJ thought. That's not what she did. That's not what the proposed decision says. In fact, the administrative law judge is very experienced. She knows that if there is a probation violation, it's charged as such. It was not charged in this case. They see it often. She did not see it in this instance, and that's why she did not treat this as a probation violation. If you look, for example, let's see. So the argument that respondent is making that because the conduct was in 2 separate proceedings, that it should have been rolled into one and that he was somehow treated unfairly, I think that's another important mischaracterization. If you actually look at the facts of the case, of the 2 cases that are before the board, you had 1 event that occurred in 2012 and 2013 involving 2 patients in another city and county up towards Lake Tahoe. So that was the 2014 case that did not become final, it's true, until shortly before the hearing commenced in this case, but that was because respondent took many time, he sought 2 continuances in that matter and then filed a writ. So it did not become final until that time, it's true. But the conduct that occurred in that case happened in 2012 or 2013 and 2013. Contrast that with the conduct that occurred in this case in 2017. So the claim that these are being charged or prosecuted in an episodic fashion or piecemeal and that it's somehow unfair to him is not the reality. That's not the facts that you're presented with. The significant fact that the ALJ considered is that you had respondent committing on 2 separate events involving 2 patients in one instance and 1 patient in another instance. The same similar types of problem shows a pattern of conduct and behavior that is more serious than if it was a one-time incident that was not separated by, for example, in this case, 3.5 to 4 years involving different patients. So that's why she treated it as not a probation violation, but a disciplinary consideration to take into account that such events had happened in the past with respondent. This was not his first experience having this concern with patient safety. So for respondent to claim that, that can't be considered a valid disciplinary consideration would be to say that nothing can ever be considered a disciplinary consideration unless the person is actually on probation for it. And we know that's not the case because we have separate statutes and standards for when a person commits a probation violation. It would be like if a person committed a DUI in 2012 and then another one in 2016. If because of the way the legal practice happened, the decision wasn't final and so it wasn't actually on probation for one before the other happened, that doesn't mean you can't consider the seriousness of repeated conduct. And that's exactly what happened here. And then I also need to address one of the main concerns and considerations, which is respondents' claim that because this was simple acts, what are repeated negligent acts means they're not gross negligence, that are simple departures, that they don't implicate his fitness to practice. And specifically, that is at page 5 of respondent's brief. And I want to actually cite what he says here because it's wrong and it's something that needs to be addressed. He says, simple departures hardly implicate respondent's fitness to practice, as the ALJ apparently believed. Now, you'll notice there's no citation to any law or standard there. That's simply an assertion, and it's an assertion that is not well-reasoned and that is false. Because stop and consider what the actual departures from the standard of care were in this case. It started out with failing to take and document an adequate history and physical, one of the very first experiences that a patient has with a physician. It continued on to taking a wrong test, a test that was not indicated or necessary for this patient. And then as the care progressed, it continued to prescribing a medication that was actually contraindicated for this patient. And finally, in terms of dealing with how to take the medication, there was a lack of patient communication and conduct and understanding, and what the ALJ noted to be a lack of actual compassion and responsiveness to this patient who had questions about how to take this medication. So to claim that not taking an adequate history and physical, prescribing a medication that is actually contraindicated, given the patient's prior history of suicide attempt, which respondent failed to discover or address, to claim that these are not departures, that these departures have no bearing on his fitness to practice medicine is simply not reasonable. It's false. They're core functions of safe and competent medical practice.
Counsel, you have 5 minutes left.
Thank you. As is failing to communicate with the patient regarding how to take those medications. Failing to address with that patient the risks and benefits of taking those medications. Informed consent. These are not minor issues. Whether they're classified as simple or extreme does not change the fact that in this case, the respondent's conduct fell thoroughly below the standard of care in every aspect of his interaction with this patient, and that it put the patient at risk. That's what the expert in this case opined, the only expert who testified, and that's what the administrative law judge properly found based on the only evidence before her in the record, which is reflected in the proposed decision before you. Finally, An issue that was repeatedly referenced both in the brief and then in the argument here today on respondents' behalf is this claim that this is not a particularly serious case because there was no patient harm. Now, that's a very troubling argument. It's one that was raised by respondent at the hearing, and the ALJ shot that down. And the reason was because respondent was asked at the hearing. I asked him, have you followed up with this patient? You treated this patient for a matter of, 3.5, 4 months during the course of 2017. Did you ever speak with her after that time? Did you ever follow up to find how she was doing, whether the medication that was contraindicated that you prescribed had any negative effects on her? The answer to that was no. So to assert without evidence that there was no patient harm in this case is irresponsible. It's another mischaracterization of the record. The fact is we simply don't have evidence going to that point. But that is not the consideration for the board. Unlike a medical malpractice case where you seek to compensate a patient for damages, the board's reason for being, its existence, is to prevent patient harm, not to compensate patients for harm after it's already occurred. And that's why the ALJ noted the type of conduct that respondent committed here is negligent in that it could cause patient harm. Whether it did or not is not the point. It is interesting, and it was something that the ALJ properly took into consideration, that respondent would rather flippantly make comments about there not being any patient harm when he did not know that. And that was another issue that she addressed, which specifically related to the respondent's conduct and his mannerisms before the board, his ability to receive criticism, to learn from it, to benefit, to be rehabilitated so that he will, in fact, could become safe to practice as a patient and safe for patient care. And in that regard, the board should really take considerable attention to paragraph 60 of the proposed decision. It's kind of the elephant in the room. It's not something that was addressed in respondent's argument or his brief. But the ALJ here found that respondent failed to understand the seriousness of his conduct, that he had a sarcastic attitude towards the whole proceeding, that he made remarks about how his secretary's handwriting was bad, and so, maybe the board should take action against her too. Now, that was clearly a reference, and he admitted he was being sarcastic. It was clearly a reference to the fact that this is the second time he's been in front of the board for issues like documentation, like ordering tests that are not appropriate for the patient's care, and yet he has no insight. He took no responsibility, no even respect for the fact that the board is trying to protect patients and that should be his concern. Instead, the ALJ found that respondent's preference for his own medical judgment over that of others poses a danger to his patients. So the claim that the ALJ was confused, she misconstrued the evidence, or she thought this was a probation violation, that is clearly not what happened. What happened here is that the ALJ found that respondent is a danger to patients, and that's why the condition precedent was ordered.
Thank you. Mr. Garcia, you have 5 minutes.
Thank you very much, Your Honor. I don't want the panel to be misled about anything here. Patient harm, I've never claimed, and not in this case or any other case, is not a prerequisite for the exercise of disciplinary authority by the board. Mr. Carroll is correct in saying that. We don't have to wait for patient harm to occur before the board can take action. The reference to the lack of patient harm, rather, is a mitigating factor of sorts. In other words, if you look at the conduct, I'm not saying that the board can't take action. I'm not saying that unless patient harm is shown. That's not what I'm saying. But when there is no patient harm, that's a consideration to be taken into account in fashioning an appropriate penalty. That's the only point that was being made there. Now, in terms of not backing up any, no legal background or citations to this concept of fitness to practice, I disagree with counsel. I think I went into it in great detail, both in the written argument and in my comments today. This notion of fitness to practice is the language of incompetence by statutory and case law, and I cited that in the written argument. So when you start talking about a person's fitness to practice, you're not talking about negligence anymore. Negligence is a departure from the standard of practice. They're two different concepts. So when the ALJ starts using language that is within the realm of this definition of incompetence, I think you need to ask yourself, was she on the right track? So I did cite law to that effect in the written argument and in my comments today. As far as the taking into consideration conduct that occurred in the other case, when that case had not yet become final. Remember this, your decision, the finality of your decision is the ultimate decision in the case. So while that decision has not become final yet, that means the findings, the determinations made in that decision cannot be relied on yet because it hasn't become final. So when the ALJ starts referring to conduct in a decision that became effective after the filing of this case, I think it's inappropriate. And I never said it was a probation violation. I said it was treated by the ALJ as an aggravating circumstance, looking at this other case and saying, oh, well, that's reason for me to impose a harsher penalty here because of the conduct that occurred in that other case, which did not become effective until 2 months after this case was initiated. That's the problem I have with it. And I think that's unfair to the doctor to do that because until this board's decision becomes final, until that time, you really can't consider what went on in that decision. Other than that, I didn't go into the facts of the case. One of the reasons I didn't do that is because I didn't have a transcript. And if there is anything there, and I trust Ms. O'Carroll completely because I've worked with her in the past, if she says there's something in the record there that's incorrect, then I'm not going to dispute that. And I apologize to the panel if there was any misrepresentation. It was not intended. That's where the transcript comes in and where it's so important. And one final point. There's a distinction between having the opportunity to purchase a reporter's transcript and the right to have that transcript provided by the board under the statute that I cited. There's a complete distinction there. And I don't think the doctor has to go out and purchase a transcript if the law says he's entitled to one. And in fact, that's what that statute says. And I read it to you, and it's in the government code there. And so that did impair our ability to present an oral argument here. I'll submit it. Thank you.
All right, thank you. Ms. O'Carroll, 5 minutes.
Yes, Your Honor. With regard to the legal standard, the legal question of fitness to practice and whether or not that invokes incompetence as opposed to negligence, I think it's significant to note that incompetence, gross negligence, and repeated negligent acts under the disciplinary guidelines are all treated with the same minimum and maximum. You have a maximum of revocation, you have a minimum of 5 years probation with the various terms and conditions, one of which includes the clinical assessment program. So the question that whether the penalty is appropriate really is a moot point. Like if you're trying to argue that apart from the common sense issue that respondent is potentially endangering patients, the board wants to protect him and protect patients and stop that from happening, and so they want to impose the standard. The question of whether it's legally appropriate is answered by the disciplinary guidelines, which say that regardless of whether it be incompetence, gross negligence, or repeated negligent acts, these are the range of appropriate penalties that the board can impose. And one of them is 5 years probation and the clinical assessment program, which is exactly what was ordered by the ALJ in this case. So that need not concern you. Finally, also, as to the question of the transcript, I need to note that when I referenced earlier the statement about how respondent actually made an admission that he did not ask the patient about street drugs and alcohol, and yet argues in his brief before this panel that maybe he did and the expert misunderstood. That evidence that I cited was not in the transcript. That evidence is in Complainant's Exhibit 12. That was the interview with the board staff. So there's no question here that there was any confusion or misunderstanding. There was an attempt to make the evidence and the conduct seem less serious than it is, and the board should not be misled by that. And respondent had every opportunity to obtain that information and evidence. In fact, has Exhibit 12. So there's no question about one side not having whatever anyone else has. They do. And then really the question that the board asked, and I think we do need to get back to that, is whether or not the penalty was appropriate here, given the fact that, as respondent notes, The order for the clinical assessment program was deemed to be a condition precedent to returning to practice. And as we stated, the reason for that was because the ALJ had, based on her ability to observe respondent, grave concerns about his safety and his competence and his ability to practice without committing these types of departures. But the question about whether the board should reduce that, and at least if they do impose it, not make it be a condition precedent, or whether the board should actually take more serious action, such as, for example, revocation, is an open question. Bear in mind that it is within the range of disciplinary penalties. If the board deemed it appropriate and necessary to protect patient safety to revoke respondent's license, that would, based on the record and the evidence it has before it, be an appropriate use of discretion and application of the rules in order to ensure that patients are not hurt in the future, to prevent that from happening. If, however, the board chooses not to do that, it should certainly not reduce the penalty, because by taking respondent out of practice, given that he's already had 2 opportunities to be rehabilitated, the board would be doing no more than its duty by requiring him to establish his safety to practice if he's to continue at this point. So the floor here, in other words, what I'm saying is that the floor should be no less than what the ALJ proposed, and that the whole range of penalties, including and up to revocation, is within the disciplinary guidelines and the evidence before the board in order to protect patient safety.
All right, thank you. Any questions?
I have none. Any other panel members?
All right, thank you very much. We are off the record.
Thank you.